Imagine a man walks into a dry cleaner's, hands over a pair of fancy pinstripe pants for alteration, and when they go missing, he does not ask for a refund. He sues for $67 million. Yes, you heard that right. $67 million for a pair of pants. This is the story of Roy Pearson, a man who lost his pants and then lost his damn mind. So buckle up, because this is one wild ride through the land of law foolery. Roy Pearson was a lawyer in Washington, D.C., who in 1999 began taking his suits to Custom Cleaners, a local dry cleaning establishment owned by the Chung family. Everything was fine until it wasn't. In 2002, the Chungs lost a pair of Pearson's pants. They paid him $150 to make it right, but they told him, "Hey, maybe take your business elsewhere." But Pearson did not listen. He kept coming back for 3 more years. Fast forward to 2005, Pearson, now 20 pounds heavier, and after 2 years of unemployment, he gets a new job that requires suits. He brought in 5 pairs of pants that required alteration, including a pair of blue and burgundy pinstripes. 4 pairs came back fine, but the 5th was gone. The Chungs later found a pair of pants which they claimed belonged to Pearson, but Pearson refused, demanding $1,150 for the missing pants. But in response, the Chungs said no. In June 2005, Pearson sued Custom Cleaners for $67 million because of their same-day service and satisfaction guaranteed signs, which he claimed were false advertising. He also made demands for $3 million for emotional distress, millions more for inconvenience, and also $15,000 for weekend car rentals to take his clothes to another dry cleaners. And just before the trial, he reduced it to something he thought was more reasonable, $54 million. There is more to this story. Roy Pearson didn't just lose his pants, he lost his grip on reality. The trial started on June 12, 2007, and Pearson represented himself. To prove this great injustice, Pearson presented his dream team of witnesses. A Nordstrom salesman who testified that Pearson's pinstripe fabric was out of stock. 4 unhappy customers with minor complaints about the cleaners who all stated that they would have accepted a refund. And his own son who testified that he borrowed and returned the missing blue and burgundy pinstripes pants. Pearson's big moment came when he took the stand. He was shown a pair of gray cuffed pants and he cried, "These are not my pants. I never wear cuffs." To prove it, he brought in a photo of his closet showing 40 to 60 pairs of pants, not a single cuff in any of them. When Judge Judith Bartnoff asked Pearson if a satisfaction guaranteed sign requires a store to pay even if the customer is lying, Pearson said yes. Everyone in the courtroom laughed. But Pearson wasn't laughing. He was so serious. But it got weirder. Pearson claimed that he needed $15,000 for car rentals because Custom Cleaners was within walking distance, and now he had to go to another cleaners. The Chung's attorney, Christopher Manning, tried to reason with him, suggesting Pearson just mixed up his pants. Pearson said no, that those pants belonged to some poor, pantsless soul in Washington, D.C. Despite Manning's efforts to reason with him, Pearson doubled down and said the customer is always right. His multi-million-dollar demand was reasonable and honest, and satisfaction guaranteed means unlimited compensation. Eventually, Miss Sue Chung testified, and she also cried, "He is asking for an enormous amount of money," she said. Their policy was always to re-clean or reimburse fairly. Ms. Chung confirmed the gray pants were Pearson's because they matched the receipt number. And this is where the story gets more interesting. On June 25, 2007, coincidentally, what would have been Pearson's 13th wedding anniversary, Judge Bardnoff made her decision. She ruled in favor of the Chungs. Satisfaction guaranteed does not create an absolute unconditional guarantee. It is about what a reasonable person would expect, like, a refund or a replacement, but not $67 million. And what wedding anniversary? During the trial, Pearson described what he was going through when he filed the lawsuit. Pearson married his attorney ex-wife in 1994. Though they had no children together, she had an adult daughter from her previous relationship. In October 1999, tensions with the daughter led Pearson to ban her from the house, but the daughter visited again. So Pearson left and the couple separated. In February 2003, Pearson's ex-wife filed for divorce. Pearson represented himself and dragged out the case for nearly 2 years. His ex-wife must have worn the pants in the marriage or taken them with her because Pearson lost badly. The court denied Pearson's request for spousal support and discovery sanctions and ordered him to pay $12,000 in attorney's fees for driving up the cost with threats and unnecessary litigation. Pearson also threatened both his ex-wife and her lawyer with disbarment. He appealed, but the fees were upheld. In March of 2005, just months later, he filed the lawsuit for his missing pants. Pearson did not give up. The Chungs dropped their request for attorney's fees and sanctions, hoping Pearson wouldn't appeal. But the day before the deadline, in August 2007, Pearson filed a notice of appeal. In December 2008, the D.C. Court of Appeals upheld the ruling, stating that satisfaction guaranteed doesn't mean unlimited compensation, only just the cost of replacing the pants. Pearson did not let it go because 5 days later, he asked for a rehearing by the full court. That was denied in March 2009, but here comes the plot twist. Pearson could have pocketed some money from his missing pants. At some point, the Chungs offered settlements of $3,000, $4,000, and $12,000, but Pearson refused every time. Maybe he thought a mom-and-pop cleaners was holding out and could afford to pay a multi-million-dollar verdict. The Chungs were immigrants from South Korea who built their American dream with 3 dry cleaning shops. They paid $100,000 in legal fees to defend themselves. It wiped out their savings. With community donations, they recovered, but the stress was too much. Custom Cleaners closed in September 2007. Pearson didn't just lose his pants, he also lost his job. In 2005, Pearson was selected as an administrative law judge, but within weeks, he sent a 19-page complaint criticizing his office. By October 2007, his job was not renewed due to his lack of judicial temperament. So he sued again, claiming retaliation, demanding his job back and $1 million. And the outcome? He lost again. In 2016, the D.C. Bar finally stepped in, suspending Roy's law license for 90 days for his frivolous pants lawsuit. He appealed and lost again. And there's more interesting stuff about this guy. Since October 1999, Pearson has rented a 1-bedroom condo. When the landlord raised the rent without following the proper procedures, it sparked a legal battle. In February 2014, Pearson filed a complaint over the rent increase, leading to multiple lawsuits over 7 years. While the landlord wasn't perfect, the court found no evidence of bad faith. So the court suggested that Pearson's ongoing litigation may have been frivolous or meant to harass. But the story didn't end there. Outside his unit is a utility closet that Pearson has used for personal storage, which was secured with a padlock. In October 2021, the management company evicted him from a closet he doesn't own by clearing out his belongings and changing the locks. So Pearson filed a lawsuit against the condo board in October 2021. This case has lasted over 4 years. This guy's lawsuits are like roaches. They keep coming back. So how did this case even make it to trial? It's because of a vague and overbroad consumer protection law that allowed Pearson to stretch the law like an elastic waistband on his pants. For 2 years, judges dismissed some claims, but Pearson flooded the court with a lot of paperwork and bare minimum arguments that kept his case alive. What did the Chungs do right? Their attorney fought hard, filing motions to dismiss early and for summary judgment in April 2006. Some claims were tossed, but 2 issues kept the case alive: whether the gray pants belonged to Pearson and whether the shop's signs were misleading. What could the Chungs have done better? Maybe use arbitration clauses, get business insurance, or post clearer signs with disclaimers like certain conditions apply. In the end, Roy Pearson took the Chungs to the cleaners, but he's the one who lost his shirt, his pants, and his reputation. And that, folks, is what I call law foolery. If you enjoyed this wild ride, hit that like button, subscribe, and ring the bell for more tales of legal lunacy. Got a crazy lawsuit story? Drop it in the comment section below. Until next time, keep your pants on. And maybe don't sue over them.